Are you law curious? This program is for you. Do you feel confused or frustrated at how you want to simply know what the law says, but depending upon the news outlet you may listen to, the answer changes drastically? Not here. Straight facts on the law, no politics, no spin. Law Curious aims to answer your legal questions and legal curiosity in a simple way that makes sense, shows exactly what the law is doing and saying, and shows the different sides to questions so you can see each side without any spin. Today we are looking at Trump and the question of insurrection under the 14th Amendment. We will give you just the facts and law, no politics, no partisanship on the legal issues in the courts. And at the end of this program, we'll give you our best prediction of what we think ultimately the courts will do, straight on the law and facts. So let's start with the words of the law itself. Here is what the Constitution says, the 14th Amendment, Section 3. I've quoted it for you, and this is where we have to start because that's the law. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, in the U.S. or in the Congress or as an officer of the United States or as a member of any legislature or an executive or judicial officer where they gave the oath to support the Constitution of the United States. And here's the key language. I've underlined it for you. They shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. Now, if they have done that, that last sentence is important. Congress may, by a vote of 2/3 of each house, remove such disability. So the bottom line, under the Constitution, if you engage in insurrection, you can't hold office. That much is easy from the language. Let's get to the question, though, of what does that exactly mean? Our Constitution's language gets interpreted. Who interprets it? The federal judges. The highest group of federal judges, of course, is at the Supreme Court of the United States. They interpret the language of that Constitution in various cases that come up before them. Now, this language was interpreted once, way back in the 1800s. In that case called Griffin's case, a federal court at the time said that for the language to be applied, Congress had to first draft a law that implemented it. What does that mean? In other words, it's not just self-executing. And so Congress has to do something before one can be disqualified under Section 3 for having engaged in insurrection. In other words, you can't just run to some civil court and say, I've engaged in insurrection, therefore I'm out. It needs something to be done by Congress to put some teeth and fencing principles around what it means to engage in insurrection and how a court finds it. Anyway, that's how that Griffith's court back in the 1800s ruled. Now, the question today is, where Trump made his comments on January 6th, and on the same day people entered the Capitol building without permission, they caused damage, tried to interfere with the counting and certification process. The question is, okay, is that insurrection that Trump engaged in such that various states can deny him the right to be on the ballot? Is that insurrection that Trump engaged in? And if so, who says that he engaged in insurrection? Specifically, can it just be one civil judge in a civil case? Or does it need to be a jury of his peers? What kind of process should be employed to figure out if one engaged in insurrection? Those are the questions to figure out whether one's behavior falls within the language of Section 3 such that they can be removed from a ballot. Courts have split. Famously, the Colorado Supreme Court is the court that has set this issue up for Supreme Court review. The Colorado Supreme Court split on how to interpret this language within our legal framework. 4 judges said yes, insurrection. 3 said nope, not insurrection. So I'm going to give you now the 2 sides to the question. Let's start with the insurrection camp, who see these as the relevant legal principles interpreting the language. The insurrection camp says that language is self-executing. What that means is it applies by way of the amendment and does not need Congress to adopt some specific legal framework to allow it to take effect. In other words, they said that case I talked to you about, they interpret that case as being wrong and improper. They say the language of the 14th Amendment, Section 3, is more like the 13th Amendment, prohibition on slavery. It was and is self-executing. It doesn't require Congress to pass a law to actually free the slaves. The adoption of the amendment itself freed the slaves. The other point that the insurrection camp makes is that who is qualified or not due to an insurrection, it's a typical legal question. It's like who committed a battery, who infringed a copyright, who stole a car. It's a legal question for courts. It's not a political question that just belongs in the political branches of government. They say Colorado had a case. A judge looked at the question. The judge looked at it by clear and convincing evidence. The judge held a trial, and the judge saw a bunch of facts and concluded those facts equaled Trump engaged in insurrection. So let's look at the facts that the people on the insurrection side say occurred that justified the judge's conclusion that Trump engaged in insurrection. Number one, insurrection means a public use of force or threat of force by a group to hinder or prevent the execution of the Constitution. It's more than a riot, but it's less than outright rebellion. Starting with that definition of insurrection, they say, okay, January 6th had people by force enter the Capitol with weapons. They fought the police who were there. They entered to hinder or prevent the electoral count that was occurring. And the judge in Colorado, the trial court judge, found that Trump engaged, quote unquote, remember that's the language that we're talking about in the Constitution, he engaged in this because of his words. Things such as the only way to lose the election is if it's rigged. He refused to say he would commit to a peaceful transition. He exerted pressure on Republican Party members in certain states. His, quote, stop the stealing, quote, verbiage fanned the flames of his supporters. And there had been some violence in prior months at some of Trump's rallies, and he justified the violence against Antifa, for example, as self-defense. On January 6th, Trump gave a speech in D.C. where he said that he was there to save democracy. We have to fight harder and not be like a boxer with hand tied. We got to walk down to Congress and cheer the Congress people on. You have to show strength. We fight like hell. When he was told the mob was chanting hang Pence, he allegedly said perhaps he should be hung. Trump also chose not to testify in that trial, so he didn't offer any testimony about what his intent was in terms of words he said and how those may connect to the behavior of the people at the Capitol. And so what the Colorado insurrection viewpoint is, those messages, you put them together like a jigsaw puzzle, and the picture the court sees factually is someone who clearly and convincingly did engage in insurrection and a call to arms to his supporters. The other legal precept the court said is that Trump's words, they're not protected First Amendment speech because they did encourage imminent use of violence, and those types of words don't get First Amendment protection. Now let's look at the other side of this question, and that's the no insurrection camp. The judges who said there was no insurrection under the 14th Amendment here look at the clause and the language we looked at and said it's not self-executing. That old Griffin case from the 1800s, it was right. There has to, in other words, be some sort of proper procedures and structure that's enacted by law and then employed to assess whether someone has actually engaged in insurrection. For example, they note, we actually do have procedures because Congress did pass insurrection laws, criminal ones. But here the federal government chose not to charge Trump with them. He's been charged for lots of things related to January 6th and other things. And so the absence of a federal criminal indictment for insurrection means at least the federal prosecutors don't believe that they could prove beyond a reasonable doubt that Trump engaged in insurrection. In other words, charging him under the federal law that was passed, which should be the enacting legislation, that's how you prove someone engaged in an insurrection. And if you don't do that, that process hasn't worked properly. Now, certain things can be dealt with by state judges to determine eligibility to stand for office, such as you have to be 35 years old or born in the U.S., because those are pretty simple black and white factual questions. But what the no insurrection camp people say is, this is different. When you're talking about who is an insurrectionist under federal law, that's a type of question that requires very, very significant factual findings and a very, very significant proper set of due process protections, a procedural process in place that allows that finding to be made and to stick. Here, Trump didn't have a proper trial, they say. There was no jury of his peers. There was no discovery allowed in that process, no subpoenas to compel witnesses, and it wasn't done beyond a reasonable doubt. It was done by a lower standard. The Colorado state law allows preponderance of the evidence. The judge apparently applied somewhat higher standard of clear and convincing, which you can think of as being like 65% or something like that likely to have done it. In other words, the no insurrectionists say that the state qualification trial process was simply too abbreviated. And they say that if you're to look at the words of Trump, like many people did, you can't say that as a matter of law, he was provoking an insurrection. Maybe if you put all those facts before a jury, maybe a jury would say beyond a reasonable doubt he did it. But maybe a jury would say he didn't do it. And the point being, we have to certainly at least demand a jury of peers look at this with the highest of burdens of proof, rather than let one solo judge make such a profound decision. The other issue that's embedded in that the no insurrectionists say is that Trump said lots of things and people did lots of things, but connecting the two with the conclusion that he was engaging in or coordinating or advancing that behavior, it's a very complicated factual question, and that's why this deeper process is needed. Maybe when he said fight, did he mean literally storm the Capitol or fight? Or did he mean it in the way it's often used, fight on, etc.? These are really complicated questions that require a deeper process for fact-finding. And that's the bottom line of the no insurrectionists. So now you've seen each side interpret the Constitution differently on whether it's self-executing, and they then interpret differently if it is proper to be adjudicated by a court, what kind of court, what kind of trial, what level of evidentiary standard, what amount of discovery is someone entitled to before they're labeled an insurrectionist. Legal minds of good faith disagree on this. So the question now is, what will the Supreme Court do? You have the legal framework to better understand this dilemma now, just the legal facts on this question. As to what the U.S. Supreme Court will do, my best guess as a lawyer looking at just the law and the legal precepts is that the Supreme Court will side with the no insurrection camp and reverse Colorado's decision. So there you have it. For those of you who are law curious, check out our other programs where you can learn all manner of current contemporary legal issues in a simple, just the facts manner. Thank you.